And hello once again, and welcome to Employment Hour in 30. I'm John Scholes. I'm not the guy that matters. He's the guy that really matters, Lior Samfiru. We are here to talk about employment rights, workplace rights. Could be severance, could be sickness, could be a bad boss, it could be workplace harassment. There is tons of stuff to talk about every week. And we will get to a bunch, including the Severance Pay Calculator. Anytime you need to get a hold of Lior, that is easy as well. help@employmentlawyer.ca is email, and 1-855-821-5900 is the number. We always like to start off with Lior with the week that was, something that's been happening in your world that will be of some interest to our viewers. So what do you got?
You know, one of the most interesting or rewarding feedback that I get is people say that, you know, I watched the show not because I had any need, because I thought it was interesting. And then guess what? A few weeks later, something came up and made me think of the show and something that you said, which is great. And that's exactly why we're here, because you hopefully don't have any workplace problems right now. Maybe things are going well, but you still need to be armed with knowledge and the information that you need to have in case there is a problem, in case something does happen, so that you know what to do, you know how to respond. Maybe you lose your job. Often when that happens, you don't expect it. Yep. Or maybe your boss says something or does something that changes the terms of your employment change, and you need to know what to do. So that's what we're talking about right now. You'll find out a lot of things about your rights in the workplace, what the law says, how the law can help you. So stay tuned. And we always talk about a couple of situations, or at least one situation that I saw come across my desk. This is an interesting one, John. So this person called me. He was let go. He had worked for a company for quite a few years. I think it was about a dozen years. Mm-hmm. And when he was let go, the company paid him a year's pay, or offered him a year's pay, which was not bad for him. But here's the thing. He was in a very, very senior position. Right. And one of the things that his employment agreement said is that if you leave, you're going to not compete with us. You're not going to work anywhere in the industry for 18 months. We call that a non-compete. So he said, well, wait a second. They're going to pay me for 12, but they expect me not to work for 18. Well, what gives? How am I going to make ends meet? Right. I can't find a job. He was in a specific industry, and that's all he's worked. So he wanted to know what that means. The reality is, John, for most people, non-competition agreements are not enforceable. Okay. For most people. So even if you sign one, the law says you can't really prevent someone from working wherever they want to work. But for some people, usually senior executives, they are enforceable. For this particular person, it was enforceable because he was very senior. But because of the fact that the company was going to bind him for 18 months, they had to give him more severance. They have to compensate him more. You can't just say, well, we're not going to pay you much, but you have to avoid working for a long period of time. No, exactly. So one of the factors that go into calculating how much severance you get can be whether or not you're bound by a non-competition obligation. The company can't have it both ways. If they want you not to work, they have to pay you. So I said, well, they should probably pay you right around 18 months' pay, and I'm going to be working with him to make sure that he gets that. So I want our viewers to understand that there's a number of factors that go into how much severance you're owed. The main factors, of course, we know those: age, position, length of employment, but there's other factors. One of them could be, are you bound by a non-competition obligation? If you are, that may mean you get even more severance than you would normally.
You can check out our radio show as well, employmenthourtv.ca. You want to find out where you can catch the show. We've been doing that for over 5 years now. We take a ton of phone calls. We like to play them back on this show so you can hear them, get some feedback, and really just learn a little. So we'll get to a call.
I have a friend who works in sales. She's been with this company for about 8 years. When she travels, certain things are paid for by the company. Some things are her own expenses. She still writes off certain things such as gas, mileage, and etc. She has to give them her schedule, her availability, which is 7 days a week. She doesn't work for anybody else, exclusively for him. Recently, they had a cutback and she got let go. She got no severance. Is she not entitled to severance?
Oh, yeah.
Yeah, the answer is, oh yeah, she is 100% entitled to severance. But let's break this down and elaborate. So clearly they treated her as an independent contractor. They treated her as something other than an employee. There's a number of terms people could use: being on contract, being a freelancer. All those things mean that the company doesn't consider you to be an employee, but it doesn't really matter what the company considers. The law decides whether you're an employee. The person doesn't decide, the company doesn't decide. So if she worked there exclusively for them, if she was available for them 7 days a week, she's been doing it for 8 years, then she is an employee. Not even a question. And a lot of our viewers are going to be surprised by that, saying, well, wait a second, if she's paying her own taxes, if the company says she's not an employee, how can she be an employee? It doesn't matter. The law decides that. So if she's an employee, then when they let her go, of course they owe her severance. So how much severance? Well, the main factors we said: age, position, and length of employment. So I've taken her information, I plugged it into the Severance Pay Calculator. So let's put that up there on the screen, and let's have our viewers look at that as well. So she's in a sales role. She's been there for 8 years. I picked an age, let's say she's in her 50s. Well, someone in her situation will get 12 to 14 months of severance. 12 to 14 months. Now, even though she's supposedly not an employee, she really is an employee. Not only does she get severance, she gets more than a year's pay. So this is important. That's why we wanted to play this call on the show, because there's going to be people watching us right now who are going to be saying, what are you saying here? Are you saying that I actually was owed severance when this happened to me? Yes, you were. Hopefully it's not too late to pursue it. So if you lose your job, even if you're supposedly an independent contractor, the law may determine that you're an employee and therefore you get severance.
Yeah, we always say you got to double check, because if it were that simple for a company just to have everybody as contractors, they would never have to pay severance to anybody. That's a nice deal.
Well, yeah, but the reality is, John, the law is smarter than that. Right. Much, much smarter than that. You can't avoid the law by calling someone something that they're not. Everyone would do it otherwise. You can't do that. You can't get away with it. So the law makes that decision. It's not in your hands or the company's hands. It doesn't matter what you sign. If you look like an employee and act like an employee, you're an employee. Again,
employmenthourtv.ca. You want to find out where you can catch that weekly radio show. It's all over the place. Got many shows in the can. You can go back and listen to them as well. Ton of phone calls we get on the show. I want to get to one more before we move on.
My mother, she was hired on as a full-time employee and was originally working about 7.5 hours a day. And recently, her employer decided to reduce her hours to 4 hours a day, and without any notice. And then when we went to the HR department, they said, oh, well, we lost some business, so we had to make cuts.
Yeah, it's not that simple.
No, it's not that simple, and it's not legal.
Yeah.
So let's give the company the benefit of the doubt here. Let's assume they have a good, legitimate business reason as to why they want to reduce the hours. Let's assume they're slower. It's fine. The reality is that even if you have a good reason, even if you're not lying about the reason, the company still does not have a right to change a person's hours and compensation in this way. It's a big change, going from 7 hours a day to 4.5 hours a day. That's, I don't know, it's a 30% reduction or something like that. That's not something a company can do. If a company does that, the employee has the right to treat that as a constructive dismissal. That means she can say, no, I'm not doing that. Instead, I'm going to leave and get severance from you. It's as if the company let her go. Now, one of the reasons she may want to do that, other than the obvious that she's making less money now, is there's two reasons. Number one is if the company lets her go later, so they reduce her pay now and they let her go sometime later, the severance that she would be owed at that point would be calculated on the reduced compensation. Right. So right there, she's losing money. And beyond that, if she accepts this reduction now, she gives the company the right to do it again. So now they've reduced it by 30%. If she lets them do that next month, it could be another 30%, another 30%, and before you know it, you have nothing left. So I always say, if you're going to face significant changes to compensation, to me, that's a red line. At that point, you should be treating that as a constructive dismissal, leaving with severance. But of course, no one, absolutely no one leaves without talking to me first. Don't resign saying it's a constructive dismissal. Not till we've spoken, but that is an option you really need to consider if your compensation is being changed.
To get a hold of Lior and the members of the team, 1-855-821-5900. What should the company have done, or what could they do as opposed to trying what they tried? Just let her go straight out. If they don't have work for her, they can't afford her, just let her go.
That's a very simple option. Let her go, pay her the severance that she's owed. That's an option. Another option, they could have had, it could have been proactive, I guess, and had an employment agreement that gives them the right to reduce the compensation. The other thing they could have done is given her proper advance notice of the change. So, whatever the amount of notice she is owed based on her age, position, length of employment, so maybe it's 8 months, 12 months, give that notice. But rather than say, well, we're slow now, we're reducing your pay right now, they can't do that. There's other options. But if they do that, that's a constructive dismissal. She's owed compensation, and she probably should treat that as a constructive dismissal.
Help at employmentlawyer.ca is another way to contact Lior and the team. Want to talk about this today. We mentioned off the top, you need to watch your back when, ... Why are we talking about this today?
Well, there's certain situations, John, that if you find yourself in, you got to be proactive. You got to do something about them. You can't ignore them, because if you ignore them, you're going to put yourself in a bigger hole. So there's things to watch out for, things that when they happen to you, you got to take a step back, look at that seriously, and say, okay, I have to respond. So we'll talk about that as well as how to respond.
Number one on the list, or number 6 as we count down, I guess. You believe your employer is building up a case against you with bad performance reviews.
All of a sudden, nothing that you do is right. All of a sudden, you get criticized. You get put on a performance improvement plan, you get a negative performance
Workplace
review.
pariah.
Yeah, all of a sudden, out of the blue. Well, generally that means the company's trying to build a case against you so that they can let you go for cause. Now, if the company's building a case against you, you can ignore it. You can't just sit back and do nothing, because at some point they may try to terminate you for cause, and that's not a good thing. So you want to respond. You want to say why you disagree if you disagree. You want to put that in writing. You want to build your own case. Don't make it easier for the company to let you go for cause. So if you're being put in a situation where a case is being built against you, be proactive, be wary, respond. And if you don't know how to respond, call me.
Silence is acceptance. You always said that, right?
Silence is acceptance. It's as if saying, I agree. You don't want to do that. And if you do that later on, it's going to be difficult to say, oh, no, I did not agree with it 6 months ago. If you don't agree with it now, say so.
You need to watch your back when you've been asked to sign a new employment agreement. Big one.
A big problem. If you're already working and the company comes to you and says, I want you to sign a new employment agreement, that's fine. Don't worry about it. The salary is the same. It's all fine. Well, no, it's not fine. I promise you it's not. If it was fine, the company would not bother with it. The only reason the company is going to want you to sign a new employment agreement is if that employment agreement is better for the company. Yeah. It's going to have terms like potentially that limit your future severance, that give the company the right to change your job, to lay you off temporarily. All these things you don't want. So if the company wants you to sign a new employment agreement, take a step back. Read it carefully. Call me. Let me tell you what it means so that you're not missing anything. Yeah. You are allowed to say no. You can't be punished for saying no. Do not, under any circumstances, just sign an employment agreement out of the blue because you think it's fine. If you know it's fine because you've had it checked, no problem. Otherwise, be very careful.
And if it is fine and you do sign and go ahead, do they not still have to give you something to make it binding?
To make it binding and legal, yes, you would have to get something in return. But I don't even want to go there. Right. I don't want you to sign anything, whether they give you something or they don't, unless you know that that document is not going to come by to hurt you at some point in the future.
Again, 1-855-821-5900 to get a hold of Lior. We're talking about the times you need to watch your back. Number 3 on the list is the employer isn't being cooperative in accommodating a medical restriction.
An employer has a very strict legal duty to provide accommodation. It's not up to the employer to say, we don't want to, we think it's too much. An employer has to accommodate. And if you don't or insist on that accommodation, you may find yourself with your health getting worse. You may find yourself not being able to come back to work at all. So you have to be very concerned about it. So if your employer is giving you a hard time, make sure that you provide them with a doctor's note that says very clearly what kind of accommodation you need. That says that, spells it right out, rather than say you can't do this job. Have the doctor say, here's what you can do. Right. You can't stand for more than an hour, you can't carry more than 30 pounds, whatever it is. And if the company still refuses to accommodate, you have a human rights matter on your hand potentially, call me. But you can't ignore it. You can't just say, well, we're going to let the company decide. The law decides that, so the company has to accommodate.
And again, your doctor has the trump card. What they say goes, right? As far as your medical condition is concerned. The
company is not in a position to question your doctor. If your doctor is clear about what you need, the company is under a very strict legal duty to accommodate and provide that help that the doctor says you need.
The things you need to watch out for in the workplace. The next one, this one is so topical as of late, especially your employer won't deal with a harassment complaint.
Workplace harassment is all over the place. It's all over the news. And it's not a new issue. Employees have been dealing with workplace harassment for a long time. So a company, when faced with a harassment complaint, has to investigate. They have to take a serious look at what happened. They have to potentially even bring an outside investigator, and when they ultimately find that there's harassment, they have to fix the problem. Whatever it takes to make sure that no employee is subject to harassment in the workplace. It's unacceptable to be. So if a company doesn't do that, they ignore the harassment complaint, they don't deal with it properly, they don't fix the problem, well, you may find yourself with the situation getting worse, and now you can't feel comfortable going to work or safe going to work. It may impact your health. You may have to go off on a disability leave. So you can't let that happen. If a company doesn't properly deal with a harassment complaint, first of all, make sure that you send the complaint in writing, that you tell them what the issue is, that you ask them to respond. And if they still don't respond, if they still don't deal with it properly, at that point we need to deal with it externally. You need to call me. I can either try to push the company myself or get you out of there with compensation. But the worst thing that you can do if you're subject to harassment is to ignore it and hope things will get better. They won't get better. You have to be careful, and you have to advocate for your own rights.
What does the employee do if the person or a team that they're supposed to be reporting to the harassment is the one doing the harassing?
In some situations, it may not be practical to complain to someone because there's no one to complain to. Maybe it's a small company and the owner or the boss is the person person doing the harassment. So what I would want to do there is still find a way to document it. So if their boss said something, did something, put that in writing, either in a journal or even send someone an email confirming what was said, and then give me a call. Once we can establish that you've been the victim of workplace harassment, we can deal with it. We can get you out of there, get you the compensation that you're owed so that you don't have to continue suffering.
The number is 1-855-821-5900, help@employmentlawyer.ca. And the last one on the list is the thing you need to watch your back when you're staring right down at a termination letter.
So I'm not a mind reader, I don't have a crystal ball, but I can tell you, having done this for a very long time, that if you're staring at a termination letter and that termination letter has a severance offer, that severance offer is inadequate.
Yep.
It's a lot less than what you're owed. So, you know, I'm not a mentalist, but I can assure you that. So once you know that, like I know that, you understand you have to do something because you're owed more money. So you can't just ignore it, you can't sign it, you can't hope for the best, you can't take the company's word for it. So go to severancepaycalculator.com. We'll talk more about that in a second. Make sure you understand what you're owed. Call me. You don't like me, call another employment lawyer. But if you're owed money at a time you need it the most because you just lost your job, you better make sure that you get it. You cannot trust the company in that sense, not because they're bad people. Oftentimes the company may not know or appreciate what their legal obligations are. So make sure you understand that and be very careful.
And beyond money, there could be other components of that compensation that aren't included on that offer, and they should be. They could be huge ones, too.
Absolutely. It's not just salary. There's bonus, there's benefits. Pension has to be properly addressed. If it's not properly addressed, it could cost thousands and thousands of dollars. So important to be very, very careful as soon as you stare at a termination letter.
We will talk about probation periods, and of course, as mentioned off the top, Severance Pay Calculator is coming up next right here on the Employment Hour in 30. Stick around.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. The number anytime to get a hold of Lior and his crew, 1-855-821-5900, help@employmentlawyer.ca as well. We're talking about it. We love it. 500,000 people have gone through this and had their eyes completely opened up. Severancepaycalculator.com. Details.
Well, I talked in the previous segment about watching out for your severance. So if you're staring at a termination letter, you got to be careful. Well, I'm not just going to tell you to be careful, I'm going to tell you what to do. And the easiest thing to do, the absolute easiest thing to do is go to severancepaycalculator.com. Again, severancepaycalculator.com. It's a website you can go to on your phone, you can go to on your desktop, you can download an app if you want. And what it does is it tells you how much you're owed, how much you're worth, what the law says you should have when it comes to losing your job, when it comes to severance. It's easy, it's free, it's anonymous. There's no excuse not to use it. And maybe you haven't lost your job. Hopefully you're not staring at a termination letter, but you've always wondered. You said, well, wait a second. If they do let me go, you know, company's going through some changes.
What do I get?
What do I get?
Yep.
Severancepaycalculator.com. You can check it out right now. It's so easy to use. And if you know someone, anyone that is losing their job or has lost their job, before they sign on that dotted line, and at that point it's too late, severancepaycalculator.com.
Simple, free. You can't even pay for it if you wanted to.
Not even if you wanted to. No.
There's a contact button on the bottom as well. I'm going to run an example through here. Talk about it. You can expand on it. I know you will. Henry spent 10 years in a professional job with his current employer. Earlier this year, he was let go due to economic pressures in Canada. His employer told him that because the company has a payroll of less than $2.5 million, the law states that he's not owed any severance pay whatsoever. Is it true? What are Henry's rights?
So another misconception, another myth, and that is that only big companies pay severance, that there's this $2.5 million threshold. Now, that $2.5 million threshold has to do with a person's minimum entitlements. Your full entitlements have nothing at all to do with the size of the company or the size of the company's payroll. So Henry here got the absolute wrong advice or the wrong severance. Of course he's owed severance. So we talked about the Severance Pay Calculator. Yep. Let's plug his information into the severancepaycalculator.com website. So he's been there for 10 years. He's a professional. I picked an age, let's say he's in his 40s. So not only does he get severance, Severance Pay Calculator tells us he's owed 12 to 14 months of pay.
Wow.
So we went from not getting severance to 12 to 14 months. And look at that screen, John. The size of the company is not asked. It's irrelevant.
That's right.
It's not something you need to input because it has nothing to do with the full amount of severance that you're owed. So 12 to 14 months, it's that easy to use. Anyone can do that the same thing right now. Again, severancepaycalculator.com.
We talk about these issues. We talk about the Severance Pay Calculator. We do so on the radio show as well, employmenthourtv.ca. You want to find out where you can catch the show. Somewhere in Ontario, there's all kinds of opportunities to do so. We take a ton of phone calls on the radio show. Want to play one back and get you to comment on it.
Is it a part of law or whatnot that a person hired or not hired has a 3-month window where either party can let the other one go without notice?
The old assumed probation.
The old assumed probation. And that's the key, the assumption, the assume. No, the law does not get into this idea of probation. The only thing the law says is if you're going to be put on probation, it has to be created in an employment agreement. So if you're signing an employment agreement that says your first 3 months you're on probation and we can let you go without any notice, then that's what happens. But you cannot be put on probation automatically. It's no such thing that it's a given or it's assumed. There's no assumption. The law doesn't impose that on you or on an employer. So even if you lose your job in that first 3 months, you could be owed a few months severance. That's why it's so important to understand that even if you're supposedly on probation, but you're not really, even if you've only worked for the company for a few months, if you lose that job, again, unless you did something horrible, you're going to be owed a few months' pay. So check out severancepaycalculator.com. Call me. Short service does not mean little severance.
That number, again, 1-855-821-5900, help@employmentlawyer.ca. That's the email address. We'll take a short break, get back into more of your phone calls, and we'll get into wrongful dismissals as well here on the Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. If you're just joining us, we discuss your employment rights every week here on the show. Very important stuff. It's where you spend a lot of your time is in the workplace. And we also do a radio show, live radio show as well, employmenthourtv.ca to find a station where you can catch that. And a big part of that show, not only discussing rights, is taking phone calls. So we'll play one back like we always do in the show. And Lior, I'll get you to comment on it.
I worked for a large corporation. I was packaged out. I was told it was a result of my department shutting down. I later found out the same day that I was the only manager that was packaged out. But I know at the time I was performing better than a lot of my counterparts. So I did sign my package, but I just want to know what my rights were if I feel that I was wrongfully dismissed. I was there a total of 8 years. I was 37.
Yeah.
Okay.
So this concept of wrongful dismissal, it's worth talking about. A lot of people that call me are upset that they're let go, and they feel that the reason was not a good reason.
Why?
Yeah, and you know, they feel that the company maybe was not being honest about the reason. They let me go, but I'm a good performer. They kept other people that are not as good or not as senior. So was I wrongfully dismissed? The reality is that wrongful dismissal has nothing to do with the reason you were let go. And a company generally can let someone go at any time and for any reason, as long as severance is paid. The reason why we spend so much time talking about severance is because that's what the law knows how to do. The law knows how to compensate someone in severance. They can't make the employer change its mind. They can't make the employer justify its reason.
Be nicer.
Or be nicer, or a better person, or a more sophisticated business. So your employer can let you go for any reason. So what is a wrongful dismissal? A wrongful dismissal, very simply, is a situation when you're let go and you're not paid proper severance. If you were let go for any reason, but you were paid proper severance, that's not a wrongful dismissal.
Right.
So to know if this person got proper severance, to know if this person was wrongfully dismissed, we need to know how much he's owed. So rather than just tell you how much he's owed, let's again plug that into the severancepaycalculator.com website. So he was a manager, worked there for 8 years, 37 years old. He wasn't given any severance. Well, he's actually owed 12 months of pay. 12 months of pay. So yeah, he was wrongfully dismissed in a big way because he's owed that much compensation. So a manager in his late 30s, 8 years of service, would get right around 12 months of severance.
Yeah.
So remember, everyone right now watching us, a wrongful dismissal is a situation where you were let go regardless of the reason, but have not been paid proper severance.
First step, severancepaycalculator.com for you, and then the phone call, 1-855-821-5900. Another resource for you is terminationquestions.com. Go to that website, ask your questions. Lior, a member of his team, will answer it. You'll have some answers, and then you can make contact from that point as well. We'll get to one that says, I worked at a software company that just put 10 of us on temporary layoff as we wrapped up a major project. We have no return date, and there's nothing in our contracts that talk about temporary layoffs. Are they legally allowed to do that if they continue to pay our benefits?
There's a lot of confusion about temporary layoffs. A lot of people and a lot of companies are either misunderstanding or just not clear on what the law says when it comes to that. So let's clarify that. A temporary layoff is generally something that the company is not allowed to do. And what I mean by that, a temporary layoff is a situation where really what the company is doing is they're terminating your employment. So a temporary layoff for most people is a termination.
Yeah.
It's not something that a company can do. They're not allowed to say, well, we're going to send you home for 3 months and then call you back and it's like nothing ever happened. No, it doesn't work that way. So for most people, especially if they haven't been laid off before or they have not signed an employment agreement that gives the company the power to let them go, a temporary layoff is a termination. So for this particular situation that you read, these employees, because they haven't signed anything that gives the company the power to lay them off temporarily, that layoff, even though there was a good reason, maybe the business was slower, they just finished a major project and there was no other project, is a termination. So they have a choice now. They can accept that layoff and continue working or sitting at home hoping the company calls them back, or they can treat that as a termination immediately and get their severance right now, not having to wait. The problem, of course, with waiting at home, the obvious problem is, well, you're not getting paid in the meantime, and you're not working. But by waiting, you give the company the right to do it again in the future. So you come back to work 3 months later, and then 3 months after that,
for another 6.
For another 6, and round we go. That's not a way to work. That's not a consistent job. You can't really pay your bills that way. So because of that, I always say if the company's going to really start laying you off temporarily, you may want to, again, draw another one of those red lines and say, I'm not going to accept that. I'm going to treat that as a termination and get my severance. So those people, the ones that you read the question from, they have actually been wrongfully dismissed because they have not yet received their severance.
You know, it's funny, too. It's all in the language because someone says, oh, no, I didn't get fired. I was temporarily laid off, meaning to them it sounds like, well, I'm still there. I'm just sitting at home. Well, are you making any money?
Yeah.
No. When you get fired, do you make money? No.
So you know what's always shocking to me is these same people that are not getting paid on a temporary layoff and are accepting it, if they were getting paid 50% of what they were making, they'd probably say, oh my God, that's impossible. I can't accept that at all.
Yeah.
But now you're getting paid 0%.
Nothing.
So no, it's clearly illegal. A temporary layoff is not something that the employer is allowed to do. And you can, by the way, also use severancepaycalculator.com to find out. Now, if you've been laid off before, or maybe if you work a seasonal job.
Yes.
So some people work in construction where they only work, let's say, in the summer,
or whatever.
Paving, roofing, where you only work in a certain period of time. For some jobs, it's assumed that you're going to be on a temporary layoff because there's no work in the winter. So for those jobs, fine, they can lay you off temporarily. For most other jobs, they're jobs that are not seasonal, a temporary layoff, John, is a termination.
So don't give them the right to do it once because they'll kick the door wide open.
Yeah. It's a huge power for the company to have. It means you don't have a secure job. It's a terrible situation to be in. So I don't accept temporary layoff. I tell my clients not to accept them. If that's what happens to you, you really need to give me a call.
Email as well, help@employmentlawyer.ca. There's employmenthourtv.ca. You want to find out where you can find that weekly radio show where you get all those phone calls from. And if you haven't caught it already, if you didn't catch the previous segment, severancepaycalculator.com. That's the place you go. It takes about 30 seconds. Find out. Do not go there. Always go there. Find out exactly what your severance should be. It'll take you about 30 seconds. There's a contact button on the bottom. It's free. You don't pay for it. You got to check it out. If only for interest's sake, do it. That's it for this week. We'll get back with more next week right here, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.